Somewhere inside a VA file right now, there's a check with your name on it, not one you're collecting, one your spouse is supposed to collect the day you die, except most spouses never see a single dollar of it. Not because they don't qualify, because nobody ever sat the veteran down and explained what to file, when to file it, or why the clock on this benefit is already running right now while he's still alive. My name is Lana Maines. I'm no expert, but I spend my time breaking down the financial side of veterans' benefits. The parts nobody explains at the rating exam, the parts that only show up as a problem after it's too late to fix them. I am here to give you the kind of financial information that actually protects the people who depend on you. So, if that's useful, hit subscribe because I cover exactly this one benefit, one form, one mistake at a time every single week. Let's start with the part that catches almost every veteran off guard. Under federal law, VA disability compensation is paid to you, the veteran, for your service-connected disabilities. It is not a household benefit. It is not a joint payment. It is not part of your estate. Title 38 of the United States Code is explicit about this. The legal authority for that payment exists only as long as you're alive to receive it. The moment you die, it terminates. Not reduced, not paused, terminated. It does not matter if you're rated at 100%. It does not matter if you're permanently and totally disabled. It does not matter if that check has been hitting your account every month for 30 years. The day you die, it stops, and your spouse does not inherit what's left of it because there is nothing left of it to inherit. Look at what that means in real numbers. A veteran rated at 100% receives somewhere around $3,830 a month in 2025. Depending on dependent status, a veteran at 70% is closer to $1,760. A lot of veteran households run on that income as their primary source. Some run on it as their only source. And the day the veteran passes, that number goes to zero without warning, without a transition period, without so much as a phone call. The VA will not call your spouse to walk her through what happens next. There is no letter that arrives in advance explaining the process. If a payment happens to get deposited after the date of death, the VA will actually require that money to be returned. The system is built to pay the veteran while the veteran is alive. What happens to the family after that is an entirely separate program with an entirely separate application that somebody has to know to file. You will not hear this explained at your compensation and pension exam. You will not find it laid out clearly on the VA's main benefits page. That's not a conspiracy, it's just how the system is built. It processes what gets filed in front of it. Nobody there is evaluated on how well they prepared your family for the day you're gone. Now here's the part that matters most because it's also the part that gives you room to act. Your spouse is not without options. There's a federal program called Dependency and Indemnity Compensation, DIC for short, administered by the VA and paid monthly to qualifying surviving spouses. The current base rate sits somewhere around $1,700 a month. And it's tax-free. That's over $20,000 a year your spouse would never owe a dollar of tax on. DIC also isn't needs-based and isn't tied to your spouse's income or assets. A wealthy household and a struggling one receive the exact same base amount if they qualify. But qualifying is the catch, and it's the catch that quietly costs families everything. Your spouse does not receive DIC automatically because you were a veteran. She does not receive it automatically because you died. Qualification comes down to one of two specific paths, and both of those paths depend on decisions you make while you're still alive. That's the entire structure of this problem in one sentence. The benefit is real. The qualification depends on you, and you will not be here to fix it once it's missed. Let's go through both paths because most veterans have only ever heard of one, if they've heard of either at all. Path 1 is what's commonly called the 10-year rule, and it comes from 38 U.S.C. Section 1318. If a veteran has been continuously rated at 100% or at the combined level that meets the statutory threshold for 10 or more consecutive years immediately before death, the surviving spouse qualifies for DIC no matter what actually caused the death. Read that again. No matter what caused the death, your spouse does not have to prove your death connects to your service in any way. The length of time you carried that rating creates the qualification entirely on its own. Picture a veteran currently rated at 80% who's held that rating for 7 years. His spouse does not qualify under Path 1 yet. 3 years remain on that clock, and the clock only moves forward. It never runs backward and it never gives back time a veteran spent underrated because he never filed the claim that would have gotten him there sooner. Here's where veterans lose that window without ever realizing it. A veteran reaches 60 or 70%, feels grateful for what he has, and stops filing. He doesn't want to look like he's working the system. So the clock never starts because the rating never reaches the level that starts it. Every condition that's real, service-connected, in fact, but never claimed on paper, is a condition that isn't counted. If it isn't filed, it isn't rated. If it isn't rated, it doesn't count toward that 10-year window. Open your va.gov account today, not last year's letter, the actual current rating sitting in your file right now, and find the effective date on your combined rating. That date is when your clock started ticking, whether you knew it or not. Path 2 doesn't require 10 years at all, which is exactly why most veterans need to hear about it. This one comes from 38 U.S.C. Section 1310. If a veteran dies from a condition the VA has already recognized as service-connected, the surviving spouse qualifies for DIC. Your rating percentage at the time of death doesn't matter here. The number of years you carried that rating doesn't matter either. If the condition that caused your death was on your service-connected list before you died, your spouse qualifies. Full stop. Heart disease is the leading cause of death among men in the United States, and it isn't close. It rarely shows up announced. Hypertension feeds into it. Untreated sleep apnea feeds into it. Chronic stress and elevated cortisol from something like PTSD feed into it. Diabetes accelerates it. Weight gain from medications prescribed for other service-connected conditions can feed into it too. There is substantial research tying each of these to military service. The physical toll, the disrupted sleep cycles, environmental and toxic exposures, and the sustained psychological load that comes with the job. So ask yourself the same 3 questions I ask every veteran who watches this. Do you have high blood pressure? Is it service-connected? Do you have sleep apnea? Is it service-connected? Do you have any cardiac condition at all? Arrhythmia? Coronary artery disease? A prior heart attack? Is it service-connected? If the answer to the first part of any of those is yes, and the second part is no, Path 2 currently offers your spouse 0 protection. There's a version of this most people never think to check. Ischemic heart disease is a presumptive condition tied to certain toxic exposures, including Agent Orange. If you served in a qualifying window and location, and you've since developed a heart condition, the connection may already be legally presumed under the law. You may not even need to build a causal case from scratch. Most veterans never look because nobody ever tells them to. Take a veteran named Gerald. He's 64, a retired Army infantry sergeant from outside Fayetteville, North Carolina. He's been rated 70% for a back condition and a knee condition since 2017. He's also had hypertension for 11 years, medicated daily, and never once filed a claim for it because he figured a blood pressure prescription wasn't worth the paperwork. Gerald hasn't reached 10 years on a qualifying rating, so Path 1 doesn't cover his spouse yet. And if Gerald has a fatal cardiac event tomorrow, Path 2 won't cover her either because the condition that would have killed him was never on his service-connected list. Gerald didn't do anything wrong. He just never filed the one claim that would have closed the gap. Now let's talk about a piece almost nobody brings up because it isn't the headline benefit. It's the one stacked quietly on top of it. Under 38 U.S.C. Section 1311, there's a supplemental DIC payment available to surviving spouses who meet one additional condition. If the veteran was rated at 100% or the qualifying combined threshold for a continuous period of at least 8 years immediately before death and the veteran and spouse were married to each other for that entire 8-year stretch, the surviving spouse receives an extra payment of roughly $360 a month on top of the base DIC amount. Every month for the rest of her life, this bonus doesn't require 10 years. It doesn't require that the death itself be service-connected. It requires 8 continuous years at the qualifying rating, an unbroken marriage through that period, and a surviving spouse who actually knows to claim it because the VA does not calculate this automatically and apply it for her. It has to be requested on the application itself in writing. And here's where it compounds. If your spouse qualifies under Path 1 and also meets the 8-year marriage requirement, she receives both amounts together, the base DIC payment plus the $360 supplement stacked. That's meaningful monthly income for someone who may be managing a household completely on her own for the first time. There is also a version of this most families never think to ask about. What happens if you have a claim sitting open unresolved the moment you die? It doesn't just vanish. There's a process called substitution, where your spouse can legally step into your place and continue the exact claim you already started using VA Form 210847, Request for Substitution of Claimant. She has 1 year from your date of death to file it. If that claim gets approved after you're gone, she can collect the retroactive back pay that would have been yours, and an approved rating from that claim can also help establish her DIC eligibility. Almost nobody knows this form exists until they need it, and by then the clock is already running. Before we get to the exact steps, there's a second program worth knowing about, mainly because families confuse it with DIC constantly. It's called the VA Survivor's Pension. And unlike DIC, it's needs-based, tied to your spouse's income and assets with a net worth limit currently sitting around $163,000, not counting the home or one vehicle. There's also a 3-year look-back period on asset transfers, so giving assets away right before applying can trigger a penalty. If your spouse happens to qualify for both DIC and the survivor's pension, the VA automatically pays whichever benefit is higher, and in almost every case, that's DIC. The survivor's pension exists as a backstop, not the primary target. Everything you do now should be aimed at securing DIC first. One more detail spouses need before anything else: remarriage. If your spouse remarries before age 55, she loses DIC entirely. If she remarries at 55 or older, she keeps it. That threshold surprises almost everyone the first time they hear it, and it's worth saying out loud now rather than letting her discover it by accident later. If there are dependent children involved, there are separate DIC provisions that apply to them as well, on top of whatever your spouse receives. DIC isn't the only thing sitting behind that qualification either. Once a spouse is approved for DIC, a whole second layer of benefits often opens up that almost nobody explains at the same time. If a surviving spouse needs regular help with daily activities, bathing, dressing, managing medication, simply getting around the house safely, she may qualify for an additional aid and attendance allowance on top of the base DIC payment. Similar in concept to the special monthly compensation a veteran can receive while alive. The exact phrase aid and attendance has to appear in the written application for the review to trigger the same way it does on a veteran's own claim. Leave that language out and the extra allowance frequently never gets evaluated at all. Healthcare is the next piece families miss. A surviving spouse who qualifies for DIC is generally eligible for Champia, a health insurance program that covers a large share of medical costs for spouses and dependent children of veterans who died from a service-connected condition or who were rated permanently and totally disabled at the time of death. For a spouse who loses access to a veteran's other coverage the same month she loses his income, this alone can be the difference between manageable healthcare costs and a financial emergency layered on top of a loss she's still processing. Education benefits carry forward too, and this one surprises almost every family who hears it for the first time. Under the Survivors and Dependents Educational Assistance Program, commonly called Chapter 35, a qualifying spouse or dependent child can receive up to 45 months of financial support for college, technical training, or an apprenticeship. There's a newer, generally more generous version called the Fry Scholarship, tied to veterans who died in the line of duty or from a service-connected condition. And in many cases, a spouse or child can choose whichever program pays out better for their situation. Neither of these arrive automatically. Both require a separate application most families never realize exists until years after they would have been useful. Home loan benefits also extend to a portion of surviving spouses. If your spouse qualifies for DIC, she may be eligible for a VA-backed home loan certificate of eligibility in her own name. The same zero down payment competitive rate benefit veterans use now available to her directly for a spouse who needs to relocate, downsize, or simply refinance after losing your income. That's a resource that rarely gets mentioned in the middle of DIC paperwork, even though it's directly tied to the same qualification. Then there's the piece nobody wants to think about, but every family eventually needs: burial. Veterans who meet basic service requirements are generally eligible for burial in a VA national cemetery at no cost to the family, along with a headstone or marker, and in some cases, a burial flag and presidential memorial certificate. A spouse or dependent child can often be buried in the same plot. If your family prefers a private cemetery instead, a partial VA burial allowance may still apply. None of this is complicated once someone knows to ask for it. But in the middle of a funeral, it's exactly the kind of detail that gets missed if it isn't written down somewhere in advance. Several states layer their own benefits directly on top of DIC eligibility as well. A number of states offer full or partial property tax exemptions specifically for surviving spouses of veterans who were rated 100% or who died from a service-connected cause. And some extend that exemption for as long as the spouse doesn't remarry. A handful of states go further, offering reduced vehicle registration fees, hunting and fishing license waivers, or preference points on state employment applications. These benefits live entirely outside the federal DIC system, which means qualifying for DIC doesn't automatically trigger them. Your spouse has to know they exist and file for them separately through your state's Department of Veterans Affairs. Consider a spouse named Patricia married to a veteran named Walter for 38 years before he passed from a service-connected respiratory condition tied to burn pit exposure. Patricia's DIC claim was approved within a few months because Walter's condition had already been rated before he died. What Patricia didn't know, because nobody told her at the time, was that she also qualified for CHAMPIA for a property tax exemption in her home state, and for a home loan certificate of eligibility she ended up using 2 years later to downsize into a smaller house near her daughter. None of that arrived automatically alongside her DIC approval letter. She found out about each one separately, months apart, mostly by accident, through conversations with other veteran spouses in a support group. Walter had done everything right on his end. The gap wasn't in his paperwork. It was in nobody ever handing Patricia a complete map of everything his service had already earned her. That's exactly why Step 5 in a minute isn't just about the DIC form. It's about making sure your spouse has the entire picture in front of her, not just the first piece of it. Now, since I brought it up earlier, every veteran family loses money to the same root cause: benefits that exist on paper but never get filed because nobody flags them. So here's what I want you to do. The exemptions, the breaks, and the survivor protections most veteran households already qualify for, but never claim. I've put them all in one place, state by state, form by form, so you don't waste hours digging through government websites trying to piece it together yourself. Everything's laid out fast and simple, so any veteran or spouse can find exactly what applies to them. No matter what state you're in, there's money you're leaving on the table. It's called the VA Survivor Protection Playbook, and it's in the first pinned comment right below this video. Just tap it once and you'll have everything you need. Stay right here because the last one is the biggest bonus most spouses never claim, and it's the reason I made this whole video. Take a veteran named Dennis. He's 67, a retired Marine from outside Jacksonville, Florida. He reached 100% combined back in 2014 and has held it continuously ever since. He's been married to his wife for 31 years. Dennis has already cleared the 8-year bonus threshold. If he passed away today, his wife would qualify for that extra $360 a month automatically. But Path 1, the full 10-year rule, depends entirely on his exact effective date clearing a full decade, not just close to it. Dennis needs to check that date precisely, because the difference between 9 years and 10 years on paper is the difference between his wife having an automatic, unquestioned qualifier and having to fight for one. Dennis didn't do anything wrong either. He just never checked the exact date. For a lower income veteran household living primarily on that VA check, closing these gaps is the difference between a spouse maintaining stability after a death and facing a financial cliff the same month as the funeral. For a more financially comfortable household, this isn't survival money. It's protection that was already earned through decades of service and shouldn't sit unclaimed simply because nobody connected the dots in time. Before we get to the exact steps, let's clear up a handful of misconceptions that trip up almost every family I talk to, because getting these wrong is just as costly as never filing at all. The first is thinking DIC and Social Security survivor benefits work the same way, or that one cancels out the other. They don't. DIC comes from the VA and is entirely separate from Social Security. A surviving spouse can generally receive both at the same time in full without one reducing the other. Families sometimes assume applying for one disqualifies them from the other, and that assumption alone has kept spouses from filing for months or years longer than necessary. The second misconception is around divorce and prior marriages. DIC eligibility is tied to the marriage at the time of death, not to how many marriages came before it. If you were previously divorced and have since remarried, your current spouse is the one whose eligibility matters for DIC, provided the marriage requirements, including the 8-year continuous marriage window for the bonus payment, are met from your current marriage forward. If you have questions about a specific situation involving a prior marriage, a former spouse with dependent children, or a marriage that was interrupted and later resumed, that's exactly the kind of detail an accredited veteran service officer can walk through with you individually at no cost. The third misconception is assuming that because a veteran's cause of death is listed as something like natural causes or a general term on a death certificate, Path 2 is automatically closed. It isn't. What matters legally is whether a service-connected condition caused or substantially contributed to the death. And a knowledgeable veteran service officer, or in some cases a private medical opinion, can help establish that connection even when the death certificate itself is vague. Don't assume the door is shut just because the paperwork from the hospital or coroner. Use general language. The fourth misconception, and maybe the most damaging one, is veterans assuming that because they're young and healthy right now, none of this applies to them yet. The 10-year clock and the 8-year clock don't start when a veteran feels ready to think about mortality. They start on the effective date of the qualifying rating, whenever that happens to be. A veteran who reaches 100% at 45 and lives to 85 has had that clock running quietly for 4 decades, but only if the rating was filed and locked in early. Waiting until retirement age to deal with this someday is often the single biggest reason families end up short of both thresholds when it matters most. One last piece worth knowing before you start. You don't have to navigate any of this alone, and you shouldn't pay anyone to help you with the initial steps. Accredited veteran service officers through organizations like the American Legion, the VFW, the DAV, or your state's Department of Veterans Affairs review files like yours every single day, free of charge, and can usually tell within a single conversation exactly where you stand on both clocks and which conditions are worth pursuing. The VA maintains a searchable directory of accredited representatives directly on va.gov. Nobody accredited through that system is permitted to charge you a fee for help filing an initial claim. And any request for upfront payment to expedite your case is a signal to walk away, not a shortcut worth taking. So here's the exact sequence in order starting this week. Step 1. Confirm your current rating and your effective date. Log into va.gov, pull up your disability rating, and find the effective date tied to your current combined rating. Write it down and calculate how many years that puts you on both the 10-year path, 1 clock, and the 8-year bonus clock. Nova.gov account, yet, call 1-800-828-271-0000 and request your current rating decision letter with all effective dates listed. Step 2, audit your service-connected conditions against your actual medical diagnosis. Pull your full list of service-connected conditions from va.gov or your regional office. Then get a current problem list from your primary care provider. Lay them side by side. Anything on the medical list that isn't on the service-connected list is a claim that's never been filed. Pay particular attention to cardiovascular conditions, hypertension, sleep apnea, and diabetes. Step 3, file for any high mortality condition that isn't service-connected yet. Use VA Form 21526 filed online by mail to your regional office or in person with a veteran service organization representative. For hypertension or cardiac conditions, request a nexus letter from your treating physician connecting the condition to your service or to another condition already rated. The VA has a duty to help you gather evidence once a claim is filed, but identifying which claims to file in the first place is still on you. Step 4, gather marriage documentation for the 8-year bonus. The VA will require proof of continuous marriage across that qualifying window. So, pull your marriage certificate now. And if you've been married more than once, make sure the documentation clearly shows your current marriage date and that it predates or coincides with your qualifying rating's effective date. Step 5, tell your spouse what DIC is, what form covers it, and where your paperwork lives. She'll file using VA Form 21P534EZ, Survivor's Application for Dependency and Indemnity Compensation, and that application can only be submitted after your death. Make sure she knows the form number, knows where your rating decision letters and marriage certificate are kept, and has a contact name at a veteran service organization. The American Legion, the VFW, or the DAV all provide this kind of claims help for free at no cost to her, ever. Step 6. Set a yearly reminder to reassess. Ratings can change, medical situations change. The thresholds themselves haven't moved, but where you stand against them shifts every year. And if a combined rating ever drops below the qualifying level, the continuous year count resets to 0. Revisit this every 12 months and protect the rating you've already earned. That's the whole picture. The check stops the moment you die. DIC exists to replace part of it: aid and attendance. CHAMP VA, education benefits, and state-level protections all sit stacked on top of it once she qualifies. And whether your spouse actually receives any of it depends entirely on paperwork you either file now or don't. None of it requires a lawyer. None of it requires a fee. It requires an afternoon on va.gov of a folder with the right documents in it and a conversation with your spouse you may have been putting off simply because it's uncomfortable to have. She can't file any of this on your behalf while you're still here to do it yourself, and she won't know where to start the day she needs to if you haven't shown her first. This is yours to finish. And the only window that exists to finish it is open right now, today, whether or not you were planning on thinking about